Welcome to the Supreme Court of the United Kingdom, where today we're beginning the hearing of the appeal in the case of Begum and the Secretary of State for the Home Department. I'm hearing this appeal with four of my colleagues, whom I'll introduce now. First, the Deputy President, Lord Hodge.
Good morning.
Lady Black. Lord Lloyd-Jones. And Lord Sales.
Good morning.
The appeal by the Secretary of State and cross-appeal by Ms. Begum both concern Ms. Begum's appeal against the Home Secretary's decision to deprive her of British nationality. The principal issues raised are whether she should be granted leave to enter the UK so that she can pursue her appeal against the Home Secretary's decision. And if, on the other hand, she is refused leave to enter the UK, does it follow that her appeal against the deprivation decision should be allowed? As there have been throughout these proceedings, there are a number of confidentiality orders in place protecting certain evidence, and the name of a witness who gave evidence before the Special Immigration Appeals Commission. It's anticipated that it won't be necessary for the parties to refer to any confidential evidence in this appeal in a way that would require a private hearing. And the advocates before the court will present their submissions in a way that doesn't involve revealing any confidential information. But I should make it clear that the confidentiality orders apply to members of the public using Twitter or other social media channels in the same way as they do to professional journalists. If in doubt, you should consult the Supreme Court Communications team. The written submissions of the parties and the interveners are publicly available. References to confidential matters are redacted in the versions that are available to the public. Today, we're going to be hearing the submissions on behalf of the Home Secretary, presented by Sir James Eadie, and so I'll turn now to Sir James.
My lord, my lady, good morning. I hope you can all hear and see. I was going to start with a series of references, just because I think neither in the SIAC judgment nor in the judgment of the Court of Appeal do you have the basic background provisions all collated in one place. So it may be as well just to give you the references into the bundle by way of context. So far as citizenship is concerned, the acquisition of citizenship is governed by the British Nationality Act 1980. Section 1, in effect, you can acquire citizenship by birth or adoption. That's at page 1495 in the bundles. So far as deprivation of citizenship is concerned, the relevant provision is Section 40 of the 1980 Act, providing the Secretary of State with a power to deprive a person of citizenship, and the relevant provisions for our purposes are probably sub 2, sub 4 and sub 5 of Section 40 at page 1498 in the electronic bundles. There is a right of appeal to the first tier tribunal ordinarily from a decision to deprive someone of citizenship by virtue of Section 40 capital A of the 1980 Act. That's at page 1500 in the bundle. But by Section 40 capital A sub 2, that does not apply if the Secretary of State certifies that the decision was taken wholly or partly in reliance on information which in his opinion or her opinion should not be made public because of national security reasons. And in relation to that sort of case, the right of appeal is to SIAC, the Special Immigration Appeals Commission, where a decision has been certified to be of that kind, but there is still a right of appeal to SIAC. That's in section 2, capital B of the SIAC Act 1997 at page 1528. So far as leave to enter is concerned, as my lords and my lady will be very well aware, there is a requirement for leave to enter in a provision which isn't in the authorities bundles because it's too well known, isn't controversial for the purpose of this appeal. That provision is section 3 of the Immigration Act 1971. And again, it's a similar structure so far as appeals are concerned from a refusal of leave to enter. There is ordinarily a right of appeal to the FTT, the first tier tribunal, against a refusal of protection claims, human rights claims, revocation of protection status, and so on. That's in section 82 of the Nationality, Immigration and Asylum Act 2002 at 1524 in the authorities. By section 97 of that same act, again, not in the authorities because nothing controversial turns on it, but by virtue of section 97, there is the same sort of provision for certification of decisions taken on national security grounds. And again, so far as that type of case is concerned, the right of appeal lies to SIAC, the Special Immigration Appeals Commission, under section 2 of the 1997 SIAC Act, page 1526. If you wanted a summary of most of, if not all, I think, of those provisions, but certainly most of those provisions in the more traditional form, perhaps as good a port of call as any is Lord Justice Burnett in S1 and the Secretary of State for the Home Department at paragraphs 12 to 15 in the electronic file 2605 to 2607. That's all I wanted to say by way of introduction to the basic statutory scheme. And I wanted to turn first, if I may, to the context in which this appeal sits. Shamima Begum was born on the 25th of August, 1999. On the 17th of May, 2015, she travelled with 2 other girls to Istanbul and from there to Syria. And it follows from those dates that when she did that, she was young. She was only 15 at the time. There have been no findings yet by SIAC or anyone else about the circumstances in which she travelled. However, it is evident from the facts that followed that she and her companions were intent on joining ISIL because that is what they did. She married an ISIL fighter, lived in Raqqa, the capital of the self-declared ISIL Caliphate, and remained with them for about 4 years until 2009, when she left from, in effect, the last pocket of ISIL territory in Baghuz, B-A-G-H-U-Z. And the open assessment of national security is of some importance. It's in the bundle at page 370. If you could please turn that up. This is the open assessment that was part of the open summary of the deprivation submission that went to the Secretary of State for the Home Department. And the relevant paragraphs for our purposes, for present purposes, are paragraphs letter D, E, and F. Can I just invite you to read those paragraphs rather than me taking time reading them out. So there was specific consideration, as you see from those paragraphs, given to the likely consequences and effects of aligning with ISIL in terms of her current threat in 2019 to national security. And that assessment specifically considered the fact that she was very young when she went and may have been radicalized before she went. But that did not alter the threat that it was assessed that she posed by 2019, and nor was that assessment affected or undermined by the interview which she had given by that stage, relatively recently, I think, in that same month of February 2019, to the Times newspaper. So the assessment was that she presented a current threat justifying the removal of her British citizenship, and thereby placing serious practical and legal impediments on national security grounds in the way of her return to the United Kingdom. Annex A then picks up on both her particular circumstances and on the recent Times interview. That's on page 372. And you will have seen, if you just go back from there to 370, you will have seen references on a couple of occasions to Annex B. That's Annex B to the ministerial submission. And that starts at page 745. I don't know whether any of you are operating on paper anymore, but it's in part 2B of the appendix if you are. Otherwise, electronically, it starts at 745. And I'm going to start because, as you will see from the title at the top of page 745, and as you saw from the ministerial submission passages I've just taken you to, 745 and 746 are an update of an earlier assessment. And the earlier assessment is dated April 2017. And that starts at page 747. And you will see the nature of that assessment from section A on page 748. And an overall summary. Can I invite you to read the first and the second paragraphs on page 748? So as you will see, this assessment is specifically and directly focused on the threat from those who travel to Syria to align with ISIL and then seek to return to the United Kingdom. In other words, position in precisely the position of Ms. Begum. And you will see the overarching conclusion at paragraph 2 on page 748. You will see, travelling over to 749 and paragraph 6, that the assessment that is made in April 2017 is that the nature of the threat has developed considerably over the last 12 months. In other words, in the period leading up to April 2017. And the factors include in particular, an increase in the threat from ISIL in Europe, as demonstrated by the various attacks which are public knowledge in mainland Europe in 2015 and 16, and which one can obviously find further examples of those sorts of attacks both in mainland Europe and in the United Kingdom in the period after April 2017. But those factors leading to the development, the considerable development of the threat, were identified as at that date. There is then a whole section at paragraph 7 and following, page 750 and following, on the threat posed by those seeking to return. This is therefore precisely the territory we're dealing with, the threat from individuals returning to the UK from ISIL-controlled territory is the subject of section C of this document, starting at the top of page 750. And as you see from paragraph 7, it is both radicalization and desensitization that are the key to that threat. And the nature of the various threats that are of concern are summarized, it might be thought, in the last two lines of the quote from the Home Secretary, Theresa May, of June 2015, the last two lines of that quotation in paragraph 8 of this document on 750. The conclusion at paragraph 9 is that MI5 assesses that individuals who travelled to ISIL-controlled territory since the formation of the so-called caliphate, and those who travelled before June 2014 have remained with ISIL, will have been radicalised and exposed to ISIL's extremism and violence. We further assess that if these individuals return from ISIL-controlled territory, they will present a threat, a national security threat, to the United Kingdom. There's then a section on ISIL and the criminal law, which we can take as read, as it were, picking it up again, if I may, with the explanation as to why those are the conclusions, that is the threat, and what its basis is, picking it up again on paragraph 18 on page 752, under the title at the top of that page, Ideological Commitment to ISIL. And I invite you to read paragraph 18. And how that translates, how that ideology translates into the heads of those who go out to travel and remain in ISIL territory in this way and align in this way. See paragraph 22 over on page 753. There is then specific consideration given, particularly at paragraphs 31 to 34, or 31 on page 755, of the role of women and also children who have travelled to join ISIL, with a view specifically to assessing whether they represent a threat as well. You will see what is said about the usual role of women who travel to join the group at paragraph 31, which appears directly to replicate the position of Ms. Begum. And you will see the clear conclusions at paragraph 32, first of all, page 756. And then note the small section under the heading Radicalization in Theatre on page 756. Can I invite you to read paragraph 33 and 34, if you would? Picking up halfway through paragraph 33, as I'm sure you will, the references to desensitizing individuals to acts of brutality. So that whole section culminating in those paragraphs, you just flick back notionally to 752 and the title at the top was about ideological commitment to ISIL. And the next little subsection at the top of page 757 picks up on activities that may be undertaken by individuals on their return to the UK. And that's the subject of paragraphs 35 and following. And you will see, for example, or by way of a specific example given, in the case of a man called Harry Sarfo, in paragraph 37, the evident intent on inter alia attack planning outside the territory controlled by ISIL and into mainland Europe. External operations, as it's put. And the specific examples then given in the box of the box within paragraph 38. Read with the assessment from the security service in the second sentence of paragraph 39, that the UK will continue to be a priority target for ISIL terrorist activity. So that little section 36 to 39 is about involvement in ISIL directed attack planning, C757 at the bold heading about 7 lines down the page. They then go on at 758 to deal with involvement in ISIL-enabled attack planning, which is the next section above paragraph 40. And the practicalities of that are of some interest. See, for example, paragraph 41 on page 758. We assess that while in theatre, individuals are likely to obtain instructions and training in skills that will enable them to carry out a terrorist attack. This includes instruction in the use of firearms and other weapons. And then the point that you can't exclude from that non-combatant people who participate in non-combatant roles. Look at paragraph 43. The assessment that non-competence, I'm reading from the last 2 lines of 43 on page 759, corroborates our assessment that non-combatants regularly carry weapons and will have received some level of military training. And then they go on to consider whether that is restricted to male individuals or not. That's the subject of paragraph 45, and their conclusion is not. And you see the reference to open source reporting in the second sentence of paragraph 45 indicates that ISIL operates all female groups, including the Al-Kansa Brigade, which police the conduct of female civilians in Raqqa, including their dress and behavior in accordance with ISIL's extreme observations of Sharia law and Islamic custom. And then the final sentence, regularly carrying AK-47 assault rifles and so on. So there's no exception for women within that assessment, and neither, sadly, is there any exception for children. See paragraph 47. And so the conclusion that is reached there is really contained in paragraphs 48 to 49 on page 760. I could invite you to read those. In particular, paragraph 49, we assess that any individual, male or female, who returns to the UK, having spent a prolonged period of time in ISIL-controlled territory, is likely to have developed the capability to carry out an attack independently, regardless of whether or not they have had contact with ISIL's external operations section. We saw before, we judge that the risk of an ISIL-enabled attack occurring in the UK would increase if individuals who have been in ISIL-controlled territory return to the UK. So that's the second of the types of threat that they're worrying about. The third of them is radicalization and recruitment of UK-based associates, a well-known fundamental problem with trying to tackle terrorism in the UK, as you're very well aware. And the assessment there is paragraph 50, page 760. There is a risk that individuals who return to the UK from ISIL-controlled territory will radicalize others or impart knowledge of terrorist methodology. They may inspire, encourage, or provide support to those who have not travelled to ISIL-controlled territory to carry out attacks, and they give a specific example in the box at box 5. And then fourthly, providing support to ISIL operatives. You see what is said in paragraph 51 with the example given in paragraph 51 in box 6. They then pick up under a separate heading of the type of threat that might be posed, but it's really by way of assessing whether one can discount a threat, as it were, after a period of time. Look at paragraphs 52 and 53 on page 761, if you would, posing a latent threat to national security. Possible that some individuals who return to the UK from ISIL-controlled territory in the future may not become involved in any of the above activities, at least not immediately on their return. However, we assess that they will nevertheless present a potential threat to UK national security. Furthermore, and you see what is said in paragraph 53. So all of this, therefore, highlights the seriousness of the threats on return and the fact that the threat is real and serious, whatever sympathy might be generated by the age of the person when they travelled. And of course, you will need no reminding that threat assessment is not an exercise in certainty. Those who participate in attacks, in attack planning, in radicalization, in support, all the things being considered in this document, in the UK, have historically, as you'll be well aware, come from a variety of sources, a variety of backgrounds, sometimes with some knowledge of them in the security services, sometimes like the 7/7 bombers coming out of a clear blue sky. But the assessment, for very good reason we submit, is that those who have travelled to align and then have aligned pose a clear and serious threat, specifically on return. And that is the conclusion at paragraph 54 on page 761. Specifically focusing on return. And again, you will see the emphasis in the second sentence of 54 on the likelihood of them having become radicalized and desensitized to violence. And then the conclusion at the end of 54, the threat would increase significantly if they were to return to the UK. So that is the April 2017 assessment. And that is then updated if you go back in the bundle to 745 and 746. This deals with the position of ISIL as the year has gone by, i.e. 2017 to 2018, with the series of military defeats of ISIL. And in the light of that development, the question that is really posed in this update is whether or not there are proper grounds for concluding that the threat assessment in all its detail in April 2017 should be downgraded as a result of the fact that ISIL is and was becoming a militarily defeated force in Syria. And the answer that they give is no, in a nutshell. See paragraph 5 and paragraph 6. And the specific maintenance of the analysis which I've just taken you through, including specifically in paragraph 8 on page 746, the conclusion to which I directed your attention at paragraph 54 of the 2017 threat assessment. From that place, it's probably sensible to go to the Times interview. The Times interview was given by Miss Begum to Anthony Lloyd of the Times in the Al Hol camp in northern Syria, where she had, I think, recently arrived in February 2019. If you go to page 1088 in the bundle, you will have there the published article. You come at this published article and the interview that accompanies it with the conclusions based on desensitization in particular well in mind. The article itself is at page 1088 to 1090, and the interview in full, as in the transcript, is, I think was may have been published online rather than in the newspaper itself, is at 1091 and following. And it may just be worth picking up, first of all, on page 1088, the passage which starts about 3 paragraphs into the article. I'm not the same silly little 15-year-old schoolgirl who ran away from Bethnal Green 4 years ago, she told me, and I don't regret coming here. And I invite you to read from there to the end of the paragraph beginning with a quotation, "I was weak." Two other passages perhaps from that article. The first one on page 1090, the second full paragraph on that page, beginning, "Mostly it was normal life in Raqqa." And I invite you to read that paragraph and the one that follows it, beginning, "Her words remained." And the article ends, as you see in the final paragraph, with the statement, "I'll do anything required just to be able to come home and live quietly with my child." And I don't think I need to go in any great detail through the transcript, but just, if only to show the accuracy of the reporting in the main article, can I invite you to go to 1093 and the final question on that page? Did you ever see executions? No, I never did, but I saw a beheaded hen, a beheaded head in the bin. The bin's on the street, yeah. What was that like when you first saw that? These were the heads of captures. Yeah, it didn't faze me at all. It must faze you a bit, because I see quite a lot of severed heads, and it's always a bit like, oh, it's a severed head, quite a shock. And then she says, you see it and you think, oh, what has this man done to Muslim women and Muslim children, and who were they fighting for? And what are they fighting for, you know? They're fighting against us, they want to kill us. What would this man do if I was in front of him right now? Would he want to kill me? But instead I saw a beheaded head in the bin, and it didn't faze me at all. But he might have done nothing, says the journalist. He might have just been unlucky like your husband. Maybe he's just fighting and been innocent. No, he was a fighter that was captured on the battlefields. Oh, the guy's head you saw? Well, yeah, he wasn't a spy that was in prison. He was a captive from the battlefield, the one I saw. And then the question is asked, how did the videos of British hostages being beheaded affect you? Which occurred before you left, right? Yeah. Had that not put you off the idea of going? No, because, like, were these not journalists and stuff that were caught spying? Well, I think they were just caught being journalists, says the journalist. In a way, they're kind of like a security threat, though. Like, why do journalists, it must be slip into Syria for? And then the lack of regret about coming here, one sees at the bottom, the final question on page 1099. There's then a subsequent interview given to the Mail newspaper, and that's at 1199. That was published on the 25th of September, 2019. And you will see from that there's a reference back, as it were, to previous activities on page 1204, or previous allegations about activities at 1204. Can I invite you to read from 1, 2, 3, 4, 5 paragraphs into page 1204. She did not regret joining the caliphate, down to the end of the last full paragraph on that page. They also alleged she carried an AK-47. And then on a slightly separate topic, right, that I should show you 1208, second line on that page. What then of communications with the outside world? 1208. Can I invite you to read that little chunk, about a third of a page, stopping when you get to my parents have always been angry with me? So it might be thought that all of that, particularly the expert assessments of the nature and extent of the threat, is important to the issues that we are dealing with, but I wanted to make 3 points on the back of that, if I may. The first is that serious concerns about threats on return underpin the deprivation of citizenship when someone such as this is outside the jurisdiction. And the aim of that measure includes specifically making it very difficult for them to return, precisely because, as we've seen, the seriousness of the threat on return is what we're worrying about. But the aim includes making it very difficult for them to return on the basis that if they do so, they will pose the sorts of threats that you've seen. And I emphasize that a national security threat means a threat of the most serious kind to the public. And for that reason, engages the paradigm responsibility of the state, which is to protect its citizens, especially from the threat of terrorism, as best it can. That aim is defeated, and the public is necessarily thereby placed at increased risk if return is allowed. That, as you will recall, was the specific and express conclusion of the April 17 and updated in March 2018 assessment by the Security Service put before the Secretary of State. And that isn't at all surprising, and it isn't at all novel as a conclusion, not merely by the security services, but by the courts. Can I invite you to go into the authorities bundles if you're in hard copy, it's bundle 4, tab 58. And in the electronic, it starts at 2994.
I believe, Sir James, that we are all working purely off electronic bundles.
Very good. I just wasn't sure whether Lord Panic was as well, but if he is, I'll just simply go to the electronics.
No, I'm a dinosaur. I use hard copy.
So do I for some things, I'm afraid. So I'll spin through the hard copy references on the basis that it's only Lord Panic I'm talking to.
Thank you.
2994. This is the case of XH. And we submit that it is of real interest, and not just because Lord Jones and Lord Sales were in it. It was about the royal prerogative to take away people's passports. And the challenge that was effectively being made was on the basis of fire brigades. And it was said that once Parliament had enacted TPIMs, I'm sure you'll all be familiar with, and we'll come back to later on, but once they enacted those sorts of measures, which took over from control orders, as you will recall, and because TPIMs allowed you in certain circumstances to make orders dealing with travel documents, in effect that had implicitly removed the prerogative power in the Secretary of State to withdraw people's passports. That was the nature of the issue that was being considered. So, in effect, and in the paragraphs which are principally relevant here, which are paragraphs 94 starting on 3026, running through to the end of paragraph 98 on 3027. Perhaps it might be more convenient to invite you, first of all, just to read those paragraphs, and then I'll make some brief submissions about them. So 94 through to 98, 3026, if you would. So what the Court of Appeal was doing here, in effect, was to contrast the security effectiveness of measures imposed on a person who is in the UK, because the reach of TPIMs only extended to that sort of person, could only make a TPIM in relation to someone who was in the UK, with the need for and effectiveness of measures that could be applied to an individual outside the UK. That was the exercise of the prerogative power. That's the additional thing the prerogative power brought. And the reasoning, I respectfully submit, goes in 3 steps. Firstly, the ability to take away the passport for those who are abroad is valuable in national security terms. And that is precisely because it prevents or renders more difficult a return to the United Kingdom. Secondly, without that ability, that passport withdrawal ability, there would be, as it's put in paragraph 98, and I quote, an increase to the risk to public security. And thirdly, that having regard to those first 2 conclusions, Parliament was highly unlikely, when making the TPIM Act, to have abolished the power to cancel passports of those abroad without express provision, precisely because of its value in relation to preventing return and managing the increased risk from those abroad. We submit that's a helpful authority demonstrating all of those things. And as you will see, that analysis, particularly the first 2 conclusions about the security value of being able to do that, chime directly with the assessment that we saw from April 2017 and March 2018. That's the first point. The second point I draw from all of this material is that the nature of the risk from persons who have chosen to align with ISIL and who then return to the UK is a very serious one for all of the reasons explained in that open assessment. And thirdly, that risk does not cease to be serious because they went out when they were young, or because they may not actively have been a combatant when they were there. So the nature of the present threat on return now is in no way diminished by youthfulness when they went. That's therefore the context, and I turn against that backdrop to the fair and effective appeal issue. And the key issue here we submit is whether the consequence of a current inability to conduct a fair and effective appeal, which was SIAC's conclusion, as I will come to, is that either A, Ms. Begum must now be admitted to the UK to conduct it, or B, even more radically, that her substantive appeal against the deprivation of her citizenship should be allowed. And I focus on entry first, but I emphasize before I do so that many of the points that are to be made on entry apply equally to the option of allowing the substantive appeal. And we make 5 submissions, or submissions under 5 heads in relation to this. The first one is a short submission with no development, and it is that the procedural options open to SIAC had consequences for Miss Begum, to which I will return, but they also had consequences for the public. And it was relevant, and we submit important, to consider and weigh the latter. Indeed, the Court of Appeal's reasoning is premised correctly on that need. The second submission will require a bit of development, but the headline submission is that whilst not finally tested by SIAC, the threat assessment which you have seen is evidently both a serious one and was precisely a threat assessment relating to the return of those who have aligned and are aligned with ISIL. And by way of development of that, perhaps it's worth emphasizing the obvious at the outset. Concerns about threats have to be made, in particular, by the security and intelligence agencies in the first instance, and they have the expertise and the experience to do so, particularly in a field in which we are not dealing with certainties, we are dealing with predictive judgments, we're dealing with assessments on the basis of history and of their long and detailed experience of trying to combat precisely the sort of threats that you saw referred to and analysed in our particular context in the threat assessments I've taken you through. And you have here a detailed open assessment providing a solid foundation without more for the most serious concerns about anyone who has aligned or is aligned with ISIL. And we are dealing in the present context with threats that are in nature at a serious level. There are lots of threats to public security from crime and from other things, but these threats are in nature at a serious level. The threat is of terrorism imported back into the UK from ISIL operating in Syria and emanating from sources such as those who have been or may have been radicalized or desensitized, to take that language from the assessment, however that came about. This is not a case in which it could possibly be said that deprivation of nationality for someone outside the jurisdiction was being misused to gain some kind of litigation advantage. Indeed, to do so would be unlawful on the case law. Lots of cases from Lord Justice laws making precisely that point. But here there was no known basis for deprivation until Miss Begum left the UK. It was her travel to Syria and her alignment with ISIL that provided that basis. And she is considered to pose a real and current threat to national security. The assessment, as you saw from paragraphs D and E in the ministerial submission itself, is that she is aligned with ISIL, which might be thought to be unsurprising, given the 4 years between 2015 and 2019, and some of the material that you've seen. And it is permissible to deprive someone of nationality when they are outside the jurisdiction, just as it is lawful and effective to take away their passport, the subject matter of the XH case. The aim and object at core of both of those sorts of measures is precisely to avoid risks that would be created on return, risks of particular seriousness after a prolonged period in the environment that you've seen analysed with ISIL in Syria. And the jurisprudence, indeed, establishes that it would be lawful to wait on national security grounds until a person has left the United Kingdom, deliberately to wait until they've left the United Kingdom, even though you have your eye on them before they go, before you exercise the deprivation powers for national security reasons. That is because that may be judged to be the most effective way of keeping them out and therefore of managing the risk to national security. And that is so even though, this was the stuff of the case law, even though the effect of that would be to deny them what would otherwise be an in-country appeal right. Would you go to bundle 3, tab 38, page 2342, the L1 case, which makes that clear. Lord Justice Laws giving the judgment of the Court of Appeal, the other members being Lord Justices Lewis and Beatson, And you will see the nature of the issue if you cast your eye quickly down paragraphs 2 and 3, so page 2343. You don't need the detail just to get the shape of the issue from those paragraphs. The core point being deliberately deprived when out of the jurisdiction, where the effect would be no in-country right of appeal following from that deprivation in that way. And the key analysis of the court, again, I'm going to ask you to read paragraphs if I may. The key analysis of the point is between paragraphs 20 and 26. 20 begins on 2349. Can I just invite you to read that page and a half, if I may? So the conclusion in a nutshell, as you will see, is that there is nothing in the legislative regime, see paragraph 25, nor in the common law, see paragraph 26, to prevent the deprivation of citizenship, even though it has the effect, which will have been known and was known for the Secretary of State, of depriving someone of an in-country appeal that would otherwise have applied. And it's a key part of that reasoning that the powers to deprive are given to be exercised on national security grounds. They are the paradigm example of conducive to the public good. And so long as that was the purpose for the exercise, and not to obtain some tactical advantage, then there isn't a Padfield problem. There wouldn't be a Padfield type problem. So you can do it in this way. There's nothing wrong with doing it in this way, and the powers are there to be exercised inter alia to protect national security. And the concern when the powers are exercised in relation to someone who is outside the jurisdiction is precisely about their return to the United Kingdom in those circumstances. We saw that from the April 17 assessment. We saw it from the March 18 assessment. We saw it acknowledged correctly in XH. I should have said that in XH it worked both ways there, if I can put it that way. There was a real concern about people going into that environment. So taking away their passport stopped them leaving the United Kingdom to go into that environment. But that was a useful thing because it would prevent them from being exposed to radicalization, desensitization, learning the skills, being exposed to the ideology. But as 94 and 98 of XH indicate, it works the other way too. Once they've gone, and they have been exposed in that way, there is real national security advantage in preventing them coming back. And one sees that not merely from XH, but from a decision in the specialist jurisdiction, the specialist national security jurisdiction in SIAC, in a case called U2. If you go bundle 4, at 52, page 2834, and the paragraphs I want for this purpose, it's quite a long judgment that you will have seen referred to in the Court of Appeals judgment in our case, but the paragraphs I want for present purposes are paragraphs 142 on page 2871, 2871. Can I invite you to read paragraphs 142 to 144, to the end of 144? And the submission I'm going to make is that those paragraphs chime precisely with the reasoning of the Court of Appeal in XH. as they put it there in the language of proportionality, which is the challenge they were considering. I think it was an EU law challenge they were there considering, so legitimacy of aim and proportionality to the fore. But as they there put it, we do not consider, first sentence of para 144, that there is a choice of equally effective measures. Deprivation, which ensures that U2 cannot ever come to the United Kingdom unless he gets entry clearance, is the most effective way of managing the risk he poses. Lesser measures, such as a TEO, the travel exclusion, or a temporary exclusion order, or a TPIM, would not be as effective as that in managing the risk. So if you force the Secretary of State to facilitate a return to the United Kingdom, or if you allow the substantive appeal, the effect is to create potentially very serious national security concerns. You can't keep the person out of the jurisdiction in either of those events, and that is a highly valuable weapon in the armory of public protection. And there are obvious reasons why that should be so, not least, which led, no doubt, with a long experience of SIAC to the conclusions in 144, not least the limits that exist on the realistic ability of the agencies to cover in the United Kingdom all of those who pose a risk to national security. Resources are not unlimited, and the clear sorts of consequences one sees in relation to that inability to cover everyone adequately in that way if they're in the United Kingdom might be thought to be graphically illustrated by London Bridge, if no other incident, where the people concerned had been on the agency's radar and were nevertheless able to perpetrate the atrocities that were perpetrated on London Bridge. And it's entirely possible that a person presenting such a risk either goes invisible entirely in the United Kingdom, or more probably is, as it were, visible on the surface and conducting activities beneath the surface which are not detected. And that therefore leads to the possibility of them undertaking any or all of the sorts of activities that you saw analysed through in the April 2017 assessment. And I've made the overarching. This isn't about certainties, it never is. It's about managing risks in circumstances where, if those risks eventuate, they are of the most serious kind. So you have both the usual elements of risk analysis involved. How likely is it that the event will take place? But that doesn't exist as a question in isolation. Question two is always, if it does happen, how serious are the consequences or the potential consequences? And one needs to recognize the logic of the position that says you must allow someone in these circumstances to participate in the appeal, or you must allow the substantive appeal. The problem isn't confined to the present facts. It isn't fanciful to suggest that people can place themselves and do place themselves in areas of the world where they simply cannot participate effectively in this sort of appeal against this sort of deprivation decision, whether deliberately or not. Indeed, it might be thought that the hotspots for terrorist activity abroad are overwhelmingly likely to be of that ilk. In other words, places where there might be the most savage difficulties in trying to participate from abroad in an appeal of this kind. It is to be acknowledged, and I hope I've fairly acknowledged, that the precise level of threat from Miss Begum is as yet untested by SIAC. These were preliminary issues. But I want to make three short points on that sub-issue. Firstly, the expert assessment reflected in April 2017, in the April 2017 assessment, is that there is a serious risk from anyone who are aligned with ISIL. So the spectrum of risk starts from that point of seriousness and goes up from there. And it was considered appropriate in this case, as you have seen, and necessary to protect national security, to deprive her on the basis of precisely those sorts of expert assessments by the agencies that I've taken you through. And it's entirely unsurprising on the open material alone why that should be so. And as I emphasized earlier on, the assessment was that Ms. Begum travelled and did in fact align with ISIL for a prolonged period, and see the ministerial submission itself at page 370, paragraph D, penultimate line, that she, quote, is aligned with ISIL. That's the first point. Second point is that a person radicalized and perhaps desensitized when young, and who plainly should not have been, is just as much of a threat presently as a person radicalized later. There have been no findings, and indeed no allegations of trafficking or grooming made or pursued or the subject of any findings. But the fundamental point is that whether or not radicalized before departure, which can perhaps be assumed as a matter of common sense, and when young, does not alter the threat assessment. It does not alter the analysis. The key issue when you get to considering if she either has to win the substantive appeal or to be admitted to the UK is about present risk. And that risk is anchored in aligning with ISIL and everything that flows from that. Why she chose to go is at best a subsidiary issue, if relevant at all, to that current threat assessment. And as I say, the key facts, as we've seen, are that she remained in Syria for 4 years until the very end, until the fall of ISIL, the last stronghold, and aligned with ISIL, with no suggestion in the press interview she gave that she didn't travel freely. She didn't regret going. And maybe thought, giving the best one can to her, that what she says in interview may be less relevant than the sort of assessment you saw in the April 2017 professional assessment, all the more so perhaps when she was prepared in her own words to do anything to get back to the UK. But the interviews, if anything, do rather bear out than otherwise the 2017 professional assessment. She didn't regret joining the caliphate. She wanted its victory. She saw it as weakness to have left when she did. When she saw her first severed head, it didn't faze her at all. She wasn't put off travelling by the videos of British hostages being beheaded. And she wasn't put off from travelling on that basis because they were, in her mind, journalists and therefore probably were spying, and so got what was coming to them. So the concerns about national security are very real, very serious, and not undermined a jot by the fact that she went when she was very young. That's a second point. Thirdly, if it is said at this stage, it's easy to recant and assert that she has now moved position. There was some suggestion, I think, in the Mail Online interview that she now hated ISIL. No testing of that sort of case. And I note simply at this stage, and in relation to that suggestion, if it is made, the attack at Fishmongers Hall. Let's not forget that the attacker at Fishmongers Hall had, a matter of minutes before the attack, been at a seminar organised by Cambridge University on rehabilitation, where he was a guest speaker. So it might be assumed had convinced a lot of people about his rehabilitation. So although, of course, you cannot make final assumptions about the national security case because of the stage of the proceedings we're at, the precise scale of the risk above the starting point is all that has not yet been tested. But it would be entirely wrong to approach this case and the issues that confront this court on the basis either that she does not, you should not proceed on the basis that she presents a serious security risk for all the reasons I've gone through, or that she is, or that security threat is in any way undermined or diminished by the fact that she might, on one view of the world, be regarded as a victim because she went when she was so young. So that, I'm afraid, over rather a lot of development, is the second of the 5 submissions. Whilst not finally tested, the threat assessment is evidently both a serious one and was precisely a threat assessment relating to her return. The third submission is that in assessing the public interest in public protection from terrorist threat, it is vital plainly to assess the position and the threat properly. And it is entirely unsatisfactory to found judgments on the court's own assessment of potential abilities to downgrade that national security risk in the ways indicated by the Court of Appeal. And we note that that downgrading of the national security risk in that way was a, and perhaps the, critical step in its entry analysis. This also will require a little bit of development, if I may. 3 initial points under that overarching submission. The first is that the overarching answer is XH and U, those 2 cases. It's been correctly acknowledged that serious threats of this kind can be dealt with better if a person is kept out of the UK, whether by removal of passport or by deprivation of citizenship, matters not. It is conducive to the public good, the same test under each, to do either precisely because the threat is so managed. And the concomitant of that is that a return to the UK precisely recreates the risk that was attempted to be managed in that way. Secondly, the risk on return is that, on the basis of all of the analysis and assessment that you've seen, the person will, or there is a risk that they will, re-involve themselves, if ever there was a break, in terrorism. And it's simply not possible to monitor that when they're in the UK effectively or as effectively. Hence, the protective deficit of which the Court of Appeal spoke in XH and SIAC spoke in U, and as recent events, including London Bridge, indicate. Thirdly, the fact that you can have arguments about whether her case was more or less serious than U's case, and this appears to have been a significant part of the Court of Appeal's thinking, see Court of Appeal Judgment 119 to 120, is, we submit with great respect, neither here nor there. We're dealing with the risk from her. And the assessment is that she has been aligned and is aligned and would therefore be returning in circumstances creating the sort of risks, with all the analysis that underpinned them in the April 2017 assessment as updated. Her relative or comparative risk above that baseline could not be determined by the Court of Appeal in the way that they sought to do, or downgrade way. The detail of the NS case, of course, has not been dealt with by SIAC, but SIAC proceeded correctly on the basis that proper weight had to be given to that assessment at this procedural stage. See the SIAC judgment at paragraphs 144 to 5 and 189. And of course, the Court of Appeal did not have any closed material before them. I pick up until very briefly with a narrow issue / misunderstanding with the special advocates on this. The references to the documents of relevance on that issue/misunderstanding are in the new supplementary bundle, volume 2, in other words, the thin, most recent one, which I think has its own internal page numbering.
Yes, it does.
Our document is our response to the special advocate's submission is at page 26 of that. Their submission to which it responds is in the main bundle at 4756. I don't invite you to take either of them up now, but they're there for your consideration. The point that we make is a simple one. The assessment in relation to Shamima Begum is the same in open and enclosed. In other words, that she travelled, that she did align, and that she is a line. And we submit that, as the April 2017 assessment makes clear, the seriousness and extent of national security concerns as a result of those base facts is clear and pressing. But if you're getting into the precise extent, in other words, how far above that already high bar of risk, if that's where you're going to assess the final and precise extent of risk, the Court of Appeal did not have closed before it, and that closed material would have been relevant at the very least to that above the bar element of the extent or weight of risk. So we submit that the Court of Appeal should have drawn nothing from an attempt to compare the seriousness of the activities in which you had demonstrated that he or his friends had become involved and the risk that was presented by Ms. Begum. There has been separate analysis. The nature of the risks has been analysed extensively and open in her case, and that comparative analysis doesn't assist. And if it would have assisted, then they didn't have closed material to make those additional judgments about weight or extent. They then identified, seen perhaps at the closer to the heart of their analysis, that's the Court of Appeal's analysis, being fair to them, they then have identified 2 steps that in a nutshell they thought would do. We can manage the security risk in this way. That's what I mean by they thought would do. And we submit that neither of them would do, and neither of them were open to the Court of Appeal. The first was prosecution. This is prosecution of Ms. Begum on return to the United Kingdom as a way of managing the sorts of security concerns on her return that I've taken you through. So far as prosecution is concerned, we've no idea where that comes from, other than as a theoretic possibility. Prosecution and serious assessment of serious risk to the public are self-evidently almightily different things. There was no evidence about prosecution before the Court of Appeal, whether it was possible, whether it was viable, applying what would have to be considered, namely the criminal standard of proof, the extent to which you could get in a criminal prosecution to open and close issues, the public interest and all of that. None of that was the subject of any evidence or detailed consideration. So no idea whether it's possible or viable or not. Neither the police nor the DPP nor the CPS have played any part in these proceedings. And in any event, for this to be relevant as a risk mitigation measure, the premise would have to be, on return, an immediate and viable charge, an immediate and viable arrest decision, probably before court-ordered return even happened, plus an assumption that she would then be remanded in custody. So prosecution, we submit, will not do. Neither will TTIM, which was the other of the 2 alternatives. There is an obvious deficit as compared to them being outside, or her being outside the United Kingdom, for the clear and pressing reasons considered in the detailed assessment of April 2017, in XH, in U. Moreover, relying on a possible TPIM is entirely speculative. There was no evidence about that. And you would need to consider both the effectiveness of any possible TPIM, always deficient for the reasons I've given if you do the comparative exercise with someone outside the UK, and indeed whether the resource implications would permit a TPIM to be imposed. That would depend upon the true extent and nature of risk as compared to the number of TPIMs that the security service could manage at any one time. Go back again to London Bridge, where one of the terrorists had been subject to some measures and had then come off them, as it were, precisely because, as was explained in the evidence to that inquest or inquiry, precisely because you've got to make resource judgments about who you can put TPIMs on. And that involves a relative comparison with the most serious people who should be covered by a TPIM. So entirely speculative that a TPIM would even be available or would work in those practical terms. We submit entirely not possible to proceed on the basis that either that was available or that it would provide any form of sufficient or adequate protection or would serve to diminish the risk to an acceptable level. In any event, if the position is that the Court of Appeal were truly considering those options and truly considered them to be key, there was a serious procedural objection to them simply launching into a bunch of conclusions about it. If they truly thought that they needed to be considered, they needed to be considered properly, with all the evidential or factual exploration that that would entail to enable the precise extent, as I put it, above the bar of the national security risk to be determined. And the correct course at that course, therefore, would have been remittal and not an order for her return on the basis of conclusions that her risk could be managed. I should just pick up and deal very, very briefly with a suggestion in the Liberty submissions, the Liberty case, that there were other measures that could be taken, again, not explored in any shape or form in these proceedings, but simply thrown out there as a possibility. They refer to the possibility of immigration detention or bail. Again, I don't take up any time on it, but the fundamental problem with that is that in order for that to be a viable possibility as a matter of law, one would have to identify under the relevant legislation. If it becomes interesting, we can always provide a note on it, but you'd have to identify that there'd been a change of circumstances or that the leave to enter should be cancelled because the purpose of entry was different from that specified, or because it would be in the public good to cancel it. But the difficulty with all of those things is that you don't get to that place, all of which would happen in effect as a starting point at the airport, when those grounds would allow you to examine as a precursor to immigration detention, a necessary precursor to immigration detention. You don't even get to that place on the premise on which this falls to be considered. Or at least it would be extraordinarily difficult, and a very, very brave Secretary of State indeed who took on that challenge, precisely because the leave to enter, the facilitation of the leave to enter, would in effect have been ordered by the court for the purpose of participating in the appeal. So that's the third submission. I'm sorry it's taken a little bit of development. That's that if you're going to assess the public interest in public protection, it has to be done properly, and we respectfully submit that there are serious difficulties with the Court of Appeal's reasoning on that critical aspect. The fourth submission focuses, if you will, on the other side of the scales. It focuses on the weight of Miss Begum's private interest. And the submission is that the weight of her private interests does not weigh so heavy as to require now, and the temporal element is important, the increased risks associated with either her return or simply allowing her substantive appeal. And I want to make 4 submissions under that head. The numbering isn't becoming too confusing. The first is that there is no dispute about the importance of statutory appeals being fair and effective. And there is no dispute either about the significance of decisions to deprive a person of citizenship. But the contention that those entirely uncontroversial matters, or the existence of a right of appeal in the statutory scheme, provide the answer, or indeed any guide to, the outcome of this case, mischaracterises the issue. On SIAC finding, the appeal cannot be determined in that way now, but the issue here, as they correctly identified, that SIAC correctly identified at 143 of their judgment, the issue here is what the consequences of that finding is and should be in circumstances such as these. And the entirety of my learned friend's argument is premised on the fact that you have to confront and choose between allowing or dismissing the appeal, or indeed imposing the duty on the Secretary of State to facilitate entry now. And that's a false issue, we submit. Secondly, Ms. Begum's situation now in the Al-Roj camp, she had been in the Al-Hall camp, as you saw when conducting the Times interview, has now moved. Her situation in the Al-Roj camp and the problems that that creates for her appeal are not the consequence of anything done by the Secretary of State. On the contrary, they are self-inflicted. The reason that she is where she is, with the attendant problems with participating in the appeal, is that she went to Syria and aligned with ISIL. She left the jurisdiction of her own motion. The result, ultimately, of that is that she is now in third-party detention in Syria. And the SDF, the Syrian Defence Force, who are in charge of the camp, have imposed whatever rules and restrictions there might be on communications from the camp. She was not, therefore, deported, and this case is therefore not like, in any shape or form, not like the deport first, appeal later regime that was considered by this court in the Chieri and Bindlos case. I don't invite you to turn it up. It's bundle 3, tab 37, page 2307. And the relevance of the fact that these problems are self-inflicted has, we submit, been repeatedly emphasized and recognized in the authorities. I'm going to give you 2 references and take you to one case, if I may, on that. The first reference is G1, I think Lord Justice Laws again, paragraph 16, page 2126, and S1, bundle 3, page 4, tab 46, page 2601 is the first page of that. And the paragraph I want is paragraph 80 on page 2629. And the passage it may be worth just taking you to is in bundle 4, tab 61, at page 3079, which is a case called K2, and is in the Strasbourg court. It's an admissibility decision, and it starts at page 3079. This was, you might wish to just note, K2, confusingly, in Strasbourg, is G1 in England. Does that make sense? So the G1 references is this one gone to Strasbourg and renamed, just to make life more difficult. The paragraph I want is paragraph 60. Can I just invite you to read that short paragraph to yourself? as establishes the relevance of the fact of self-infliction, to put the proposition a bit more broad. Those cases, as the Court of Appeal correctly noted, concern the question whether there could be a fair and effective hearing, rather than the consequences if they could not. And it's a fair distinction to note. However, the statements of principle in those cases about not ignoring the fact that it's self-inflicted, and therefore about the relevance of it being self-inflicted, are not so limited. And it is right that they should not be so limited. Put it another way, more positively, it's right that self-infliction should be relevant in principle. The issue in our sort of case is whether, if there is a current impediment, that would prevent such a hearing. And the issue here is whether that leads either to the Court of Appeal, to this court and the courts being obliged to allow the substantive appeal, with the effect of removing the national security measure preventing her return to the UK, or that the Secretary of State has no option but to facilitate that return, which has the same effect. Or, in essence here, whether the proceedings should be stayed for the time being. And those issues raise balances between degrees of private interest and degrees of public protection. And once that is clearly understood, and it was the premise on which the Court of Appeal sought to analyse it overall, then it is plainly right to factor into the answer to that question the fact that the public would be exposed to an increased risk to safety on her return in order to rectify a situation that had nothing to do with the Secretary of State and everything to do with her. So that's the second point, the self-infliction point. But the third point is that success in her appeal will have no direct impact on her circumstances anyway. She's not detained by the Secretary of State. Her detention doesn't depend on whether she's a British citizen or not. It's possible that communications would improve, but if all depends in terms of the effectiveness of the appeal on her getting out of the camp, even allowing the appeal without consideration of the merits does not help with that. Fourthly, the extent of the problems with an appeal. The court specifically, this court specifically invited submissions on this point by the order that you made on the 7th of September. Electronic page 249. The finding by SIAC was that the inability to have a fair and effective appeal was, quote, in her current circumstances, and, quote, to that extent, the appeal would not be fair and effective. I'm quoting from the first sentence or two of SIAC's judgment at paragraph 143 at page 348. But that was, and deliberately was, why they used the language they did, a finding which, first of all, reflected her present situation at that time, not some generalized finding that a fair and effective appeal would not be possible in the future. On the contrary, they specifically recognized that lots affecting that ability could change. So it was a limited and carefully crafted finding about current inability. And one needs, we submit, a realistic assessment of the extent of the problems faced, even at that stage. This was the issue on which the court invited submission in its order of the 7th of September. it was and is accepted that at the time she could not have provided live evidence from the Al Roj camp, and that impacted on her ability to participate as a witness in the SIAC appeal. There have, however, been complaints about her ability to communicate with her lawyers. Those complaints are no doubt relative if compared with a person here and at liberty. But one needs a little care with that impediment. She had interviews with newspapers. In the interview, as you saw with the Mail, she claimed to have access to a phone, top of page 1208. More importantly, she has in fact been able to communicate, presumably about a range of issues and the launch of various sorts of proceedings, including disputes amongst her lawyers as to who was in fact authorized to act for. I don't dwell on this point. We've set out the chronology in our case, so far as those that bit of toing and froing is concerned. In our case at paragraph 17 on page 122 and 123, might be worth just getting that up on screen if that can be easily done. You'll see from those paragraphs, in particular subpara E on page 123, that there was a debate about who should act for. There were various communications that were able to be undertaken for the purpose of resolving that issue. That she was able to maintain some contact, albeit intermittent, was confirmed in her own solicitor, Mr. Furner's first statement, as summarized at paragraph 19 of the case, see page 124. And as that statement itself confirmed, see the various sub-paragraphs in paragraph 19 of our case, she was able paragraphs 13 to 15 and 4776 at paragraph 11. It is therefore we submit plain that she can communicate with and has communicated with her lawyers, and indeed has set out her version of events in media interviews. We submit that it cannot be right that we should in some way be shut out, as the Court of Appeal concluded at paragraph 93, from pointing out these sorts of things. We are entitled to submit that it's entirely possible that things might change. That is a submission of the obvious and is not affected by whether there was a direct challenge to Mr. Furner's evidence to SIAC, not least because he was only giving and could only give evidence of the current position and from his perspective about his actions. So the lack of challenge was dictated by that fact. And we must be entitled to point out, not least because it's based in significant part on her own evidence through her solicitor, that she did have some ability, it appears by phone and other mechanisms, to contact and to give instructions. That is a fact. And it's evident from her and her solicitor's own evidence in these proceedings. So one shouldn't overstate that difficulty. Next, there are complaints about providing or receiving evidence for the purpose of the appeal, and no doubt there are limitations about that. We know not why it is that the trusted intermediary could produce some documents but not those, but leave that on one side. No doubt there are limitations in her ability to do that easily or readily, but she plainly is aware of the open case against her. The case against her is, in open, a very simple and straightforward one, that she travelled to Syria and aligned with ISIL, and that she is aligned with ISIL. And she has, in fact, been able to communicate with her lawyers about that. There are then complaints about her ability to communicate with the special advocates. But the short answer to that is that the special advocates have, for some time now, been enclosed, and they had for some time been enclosed at the date of the hearing before SIAC. And they could therefore not communicate without permission, and they could plainly not communicate anything enclosed. And the rules that apply in those circumstances are designed entirely properly to prevent or to protect against inadvertent breach of the open-closed divide, with all the potentially serious consequences that might have in itself for national security. But she couldn't have communicated with the essays anyway. So one needs a realistic assessment of the extent of the problems even in her case. But it's also to be borne in mind, I've touched on it already, that circumstances can change and can change quickly. You cannot just assume that because she's in the camp and for as long as she's in the camp, she won't be able to participate in any appeal, which appears to have been the conclusion that the Court of Appeal drew at 93 of their judgment. There's no basis for that assumption anyway. It's contrary even to the evidence of Mr. Ferner on her behalf, who expressly acknowledged in his first statement at paragraph 27, page 402, that, quote, circumstances in the camp can change quickly and unpredictably. And as another example of that, if you still have our case open and you go to footnote 11 on page 126 in the electronic, you will see that even at the time that SIAC was considering these matters, there was a serious question about how the camp in the next few days, as it were, was going to be operating, if at all. And there was some reporting and suggestion there that in the light of the Turkish offensive at that date, the SDF themselves might have abandoned the detention facilities, holding the people who were in them. So the gates of the camp would have been thrown open, which would have opened up all sorts of possibilities, including the possibility of crossing the border over into Turkey. But that's simply an illustration of the fact that it's undeniable that material circumstances may change, i.e. material to her ability to participate more effectively in an appeal. And the reason that that is important is obvious. We submitted and we continue to submit that SIAC's finding was carefully and deliberately limited. And that was relevant to the possibility of a stay, which was a course that they identified as one of the possibilities open to her. Unanswerably, it might be thought, if she'd only chosen to make it, as opposed to simply moving from the current difficulties to a place where the public have to be exposed to risk, either through the success of her deprivation appeal without more, or because the government is ordered by the courts to facilitate her return. And that's the fourth submission that we make. The fifth submission is consequential. It leads, the submissions I've just made lead to a key point going to her private interests, if one is thinking about these issues in terms of a balance between public and private interests. There was a procedural middle ground which did not involve the extremity of exposing the public to increased risk from terrorism through either of the routes I've indicated, facilitation of return as an order or allowing the substantive appeal. Both have the same effect. And SAIC was correct to identify it, and the Court of Appeal were wrong, we submit respectfully, to reject it. This again requires a little development, if I may. But the very important starting point of this fifth submission is that the Secretary of State is not insisting, and SAIC were not insisting, on the appeal proceeding, or seeking finally to determine the issues despite the problems. SAIC's conclusion precisely did not mean that her appeal necessarily failed. See SAIC judgment, paragraph 191. There was nothing to prevent Miss Begum from applying for a stay on the basis that she had serious impediments to her current ability to participate and there was nothing to prevent her exercising that right in full when possible to do so. And as I said, it might be thought that was a very clear route to success in terms of an application for a stay, given the actual finding that SAIC had made. But the future is inherently highly uncertain in any number of ways, including, for example, the sort of thing that we saw as a possibility from footnote 11, the move to somewhere else where communications are easier. All sorts of other developments are possible. And a stay has the effect of holding the ring, pending the possibility of such developments. And it can no doubt be kept under review. Her case, by contrast, involves asserting that despite the option of a stay, which she's chosen not to apply for, the result of those self-created problems is that she must be allowed to return and that the deprivation cannot lawfully be maintained. Well, if that is right, that position puts the keys to her return, and indeed to the substantive kingdom, in her hands, dictated purely by her choice to travel to a place where communications are bad, she's been put in a camp and is suffering the consequences, which will be most often the case in areas of the world where major terrorist operations are in play. We submit that the SAIC course was the right, pragmatic, and not irretrievable answer to the procedural conundrum and consequences that their limited finding about current difficulties gave rise to. And it was open to them to reach that conclusion. And I make 3 short submissions by way of development of that proposition.
Before you do, James, can I just ask you to clarify one matter for me? You referred to balancing private and public interest. And I'd just like to be clear in my own mind as to the context in which any balancing, legal context in which any balancing exercise arises. Now, leave to enter the UK historically would have been a matter dealt with under the prerogative, but is now addressed by Section 3 of the Immigration Act. And we'd be talking here about leave to enter outside the ambit of the rules made under the Act, I think. And so we'd be talking about the exercise of a discretion under the Act to grant leave to enter outside the rules. Am I right so far?
Yes.
And the exercise of that discretion can be challenged by a statutory appeal on human rights grounds. And if those are engaged, then one can see that issues of balancing will arise, or it can be challenged on common law grounds by means of an application for judicial review. And under the common law grounds, is there really a question of balancing? I'm just thinking in terms of the conventional grounds of review.
Well, I think the way in which that. Sorry, I didn't mean to interrupt. Did you finish the question? In which that will work is that it would have to be said and would be said. Is the essence of the Court of Appeal's reasoning that when you get to that, because we haven't got a human rights appeal here, so he's not within the jurisdiction for A1 ECHR reasons. The way in which that will work is it would have to be a balancing of all these various interests as part of a challenge on rationality grounds to the substantive exercise of the discretion.
Yes.
That's how it would come in. So
Yeah.
one doesn't traditionally think in terms of balance within the structure of the convention. Doesn't arise in that way, but you can have a public law decision making, obviously, which involves taking into account all relevant considerations and then reaching a rational judgment. And
yes.
so it would have to be within that context, and as it were, the subtext to the application of those public law tests, that the balancing would occur.
Yes, and so the court would have to be satisfied to the Wednesbury standard that the Secretary of State's decision had been unreasonable.
My Lord, that's my submission.
Yeah.
It doesn't exclude balance. It might impose a higher hurdle when properly analysed in that way.
Yeah. Well, I mean, historically, courts have tended to be respectful of judgments as to national security, perhaps less respectful in relation to legal procedures.
Quite so. I both sides of the balance that we're concerned, which may not help, but I agree entirely with both of those.
Yeah.
And one sees that very clearly from a whole host of Supreme Court cases, which you won't need me to remind you about.
Yeah.
Lord Carlisle, Bank Mellat, all of that. But yes, I think that's the way the balance would come in under the common law framework, if that was the of my Lord's question.
That was. I was just wanting to be clear as to the legal framework. Thank you very much.
Great. So back to why it was the right, pragmatic, and not the irretrievable answer that SIAC. The first point is that one should not, in principle, I submit, have to opt for an outcome that exposes the public to increased risk, unless it's absolutely necessary. If one wants to cast that in terms of a submission about this regime, which has all sorts of legislative underpinnings with a right to appeal and all of that, Parliament would expect, it might be thought, everything to be done in the imagination of the courts that could possibly be done to avoid that final conundrum, if humanly possible. And a fortiori, you should not be doing so and determining the substantive appeal to boot, by default, against the Secretary of State, taking a measure considered to be conducive to the public good for obvious national security reasons. Obviously, if you were doing that, you would be doing so without any consideration of the national security case or its merits. You would be allowing it on procedural grounds without even having considered that case. And that would involve unfairness to one of the parties, the Secretary of State, but not just the Secretary of State as a person whose fairness is to be respected, but the Secretary of State as representing the interests of the protection of the public. And we do respectfully submit that the points made by SIAC on that point, at paragraph 146, with which I may add the Court of Appeal agreed, because this is about allowing the appeal, which they weren't prepared to do. The points made at 146 of SIAC's judgment are extremely telling. That's the first submission. The second submission is that SIAC were entitled to conclude that we had not run out of road. The existence of continuing tarmac was clear on their findings. See paragraph 191 in their judgment. proceedings are frequently stayed or adjourned for a variety of reasons. For example, to enable legal aid to be sorted out. And given the fast-moving situation and the potential for change to the core impediments, it was entirely sensible to avoid, for the time being, choosing between the two extremes in confronting the conundrum now. It can be kept under review. It's right to confront the ultimate question. Suppose you have to wait for a prolonged period, or decide for whatever reason that you have to determine if you're silent, having imposed the stay. Well, first of all, you can review the circumstances as they exist and the impediments as they exist at that time. It's simply not permissible to proceed on the basis that they will be the same as they are today. And secondly, in that dilemma, there may be some ingredients that you would otherwise wish to have in terms of fairness that are still not in place. An ability not to give video evidence, for example. But again, as the House of Lords and this court have frequently affirmed, fairness as a concept is absolute, its ingredients are not. Poaching directly from Lord Begum in Brown and Stott. It all depends on the context. And the SIAC may decide that it just has to do the best it can in circumstances where it has in effect to confront the issues. And we know that, for example, and this will be the last point I make before the short adjournment, but we know that Strasbourg has endorsed SIAC's approach, and it becoming more proactive, more inquisitorial, to use that phrase, in some extreme example. I mean, the K2 case, perhaps you don't need to turn it up now, but the K2 case, perhaps it would be worth just briefly doing it, given that we've got a couple of minutes. 3079, to go back to the K2 case, it's bundle 4, tab 61 for my learned friend. And the paragraphs I want are firstly paragraph 32, 3084. So you'll see that the context of that case was that the special advocates were declining, in effect, to act. I think because they thought it was all jolly unfair. I can't remember why they were declining to act, but they were not engaging with the substance of the closed national security case. And in those circumstances, SIAC did the best it could. It sought to probe, it introduced a precautionary approach, as you see from the beginning of 32, and so on. So on a critical part of the case to do with closed, you had, in effect, SIAC doing the best it can, without the ability of, in effect, advocates representing the interest of the person concerned in closed. Was that acceptable? Yes, it was. Go to paragraph 59 on page 3090. So that didn't present a procedural problem holding the procedure below the waterline. On the contrary, as we saw earlier, the challenges made by K2 to the way in which his case was conducted domestically were rejected as inadmissible by the Strasbourg court. So that's an example of SIAC doing the best it can in difficult circumstances, if, and I emphasize it's a big if that point is reached. My Lord, that may be a convenient moment to break.
Thank you, Mr. James. We'll adjourn now and resume at 2 o'clock.